Chapter 14, Religious Discrimination, Case 14.1 by Mary Kersey. Miguel Sanchez Rodriguez versus AT&T Mobility Puerto Rico Incorporated, 2012 U.S. Appellate Lexus 4911, First Circuit. The issue in this case is whether an accommodation should be made to permit the employee to attend services on the Sabbath. Circuit Judge Tarula. Plaintiff Appellant Miguel Sanchez Rodriguez, aka Sanchez, appeals the District Court's award of AT&T on his claims of religious discrimination and retaliation under Title VII of the Civil Rights Act. Although we disagree with some aspects of the District Court's decision, we conclude that the grant of summary judgment for AT&T was correct. Some facts about this case are Sanchez was hired by AT&T in March of 2000. In February 2001, Sanchez transferred to a retail sales consultant position in the Cagas sales region where he sold cellular telephones and accessories. His yearly salary between 03 and 06 ranged from $23,000 to $26,400 plus. Yearly commission ranged from $10,000 to $18,900 plus. In September 06, Sanchez informed his supervisors in AT&T HR department that he had become a seven-day Adventist, which gave him religious obligations to abstain from work on Saturdays and attend Sabbath services. More facts are that he requested accommodations in his work schedule by being allowed to take Saturdays off. In October 06, Sanchez presented a letter from his church confirming and explaining his religious observance of the Sabbath. Around November 21st, 06, AT&T's HR department sent Sanchez a letter stating that his position necessitated that he work on rotating Saturdays and that it would be a hardship on AT&T to grant him his request. In February 07, Sanchez presented a second letter from his church confirming his observance of the Sabbath. Sanchez also filed a charge with the EEOC office in San Juan, Puerto Rico, alleging religious discrimination. In March of 07, Sanchez had informed his supervisor that he was trying to find coworkers who would be willing to swap shifts with him, but was unable to do so. He was told that working Saturdays was a requirement of his job. Sanchez's supervisor also notified AT&T HR department about the situation. Around April 5th of 07, AT&T's director of HR sent Sanchez a letter stating policy and procedures in attendance and scheduling. More facts. In May of 07, Sanchez informed the HR department that he could not find workers to swap shifts with him and that he would therefore be absent on Saturdays. In response, the same month, his supervisor placed him on active disciplinary status. In the same month, Sanchez's supervisor also sent him 8 different emails advising him that his sales figures were below expectations. In June of 07, Sanchez applied for a retail sales consultant position in Worcester, Massachusetts. Sanchez's application was rejected on the grounds that he did not meet basic qualifications. That same month, the HR department emailed Sanchez again, informing him that his absence would be subject to the attendance policy. Finally, June 20th, 07, Sanchez tendered a letter stating an opportunity has shown up which I can have Saturdays off. In addition to it represents an opportunity for my professional growth. In the history of this case, on Sanchez's Title VII discrimination claim, the court held that even though Sanchez had demonstrated a prima facie case of discrimination, AT&T had shown either 1, that it offers Sanchez unreasonable accommodations, 2, that accommodating Sanchez would have placed an undue hardship on AT&T. As stated by the district court, to establish a prima facie case of religious discrimination, an employee must show that 1. A bona fide religious practice conflicts with an employment requirement, 2. That he or she brought the practice to the employer's attention, and 3. That the religious practice was the basis for an adverse employment decision. Judgment in the case. The court dismissed the discrimination case. The court dismissed the retaliation claim, and the district court's grant of summary judgment to AT&T on Sanchez's Title VII religious discrimination claim is affirmed. The district court's grant of summary judgment to AT&T on the Sanchez Title VII retaliation claim is affirmed. Judgment for AT&T. The First Circuit decided that it would be undue hardship to rearrange work schedules to accommodate Sanchez's religious beliefs. Reasoning. Thus, to determine whether AT&T offers Sanchez a reasonable accommodation, we analyze whether the combination offered by AT&T was reasonable by 1. Offering him the Rep 1 position and business sales position as a substitute, 2. Allowing him to swap shifts with coworkers, 3. Refraining from disciplining him for absenteeism prior to May 07. Reasoning is taken together, we believe that the effort made by AT&T constituted reasonable accommodation of Sanchez's religious beliefs. Therefore, we affirm the judgment of the district court on the discrimination claim. We need to not reach the question of whether accommodating Sanchez would have been an undue hardship for AT&T. And the final reasoning is, since Sanchez had failed to point to any evidence that AT&T's reasons for disciplining him were merely a pretext for religious discrimination, we affirm the district court's grant of summary judgment to AT&T on the retaliation claim. Following is a statistic chart showing that in recent years there has been a steady rise in religious discrimination charges filed with the EEOC. And thanks goes to the Employment Law, New Challenges in the Business Environment, 6th edition book, Google search, and Compliance Religious Discrimination, InsideCounsel.com.